We have two oral arguments scheduled today, but we'll proceed on this one first. I'm Judge Evander, and the other members of the panel, Judge Orfinger and Judge Eisnagel. Can you both see the clock on your screens?
Yes, Your Honor.
Yes.
Okay, so I'll try to assist you in keeping your time. Mr. Pierce, how much time would you like to reserve for rebuttal?
5 minutes, Your Honor.
Okay. All right, we'll give it another 30 seconds or so before we start. We don't start too early. This is our second day of Zoom oral arguments, by the way. First day went pretty well, so hopefully we won't have any technical glitches.
No pressure.
Okay.
The only one that had a technical glitch was our chief judge.
Yeah. First oral argument, I was not visual, which had its benefits.
Our YouTube was a lot higher for that one.
All right, we'll go ahead and get started. Mr. Pierce, you may proceed with your argument.
Yes, Your Honor. May it please the court, counsel. Well, good morning, and thank you all for accommodating this oral argument under extraordinary and novel circumstances. Ms. Davis, of course, Robert Pierce on behalf of Nadine Davis, by the way. Ms. Davis, of course, appeals the denial of her motion for stand your ground immunity, as well as from the apparent consideration by Judge Lemonitis of improper sentencing factors in determining her sentence. I anticipate the majority of our discussion this morning is going to focus on the first issue, the stand your ground issue, and rightly so. But I wanted to make a brief point regarding point 2, just so that that issue doesn't get lost in the shuffle. Specifically, that the state has essentially forfeited point 2 of this appeal in their response. Now, the reply brief pointed out 3 problems with the state's response. The first and most glaring is that they've acknowledged that the state did consider the truthfulness of appellant's trial testimony. The second is, of course,
Let me ask you on that.
Yes.
The judge, it seemed, was giving an explanation for why she wasn't going along with the pretrial sentence recommendation. And, you know, if the trial judge believes that the sentencing recommendation was based on either erroneous facts or a lack of facts, is the trial judge permitted to comment on that as to why the judge feels the recommendation had missing or incorrect information?
No, Your Honor, she doesn't. And I'm glad you brought it up, because that's actually where I was going. It's the fourth point I wanted to mention this morning. The problem with that is that by considering an improper factor in rejecting a potential sentence, you're necessarily considering an improper factor in determining the appropriate sentence. You can't have one without the other. So I would also contest that that is what the trial court was doing. I don't, as I pointed out in the reply brief, there's no record support for that justification. And in fact, the only mention of the PSI was used in support of the trial court's conclusion that appellant's trial testimony wasn't truthful. So she's referring.
Your client asked for a downward departure, with one of the elements being lack of remorse. Is the judge entitled to consider whether there's remorse or lack of remorse in deciding whether to grant the downward departure on those grounds?
Yes, Your Honor. I believe in Corbett v. State, this court distinguished between the consideration of remorse for purposes of downward departure compared to considering remorse just in determining the appropriate sentence. But importantly, that's not the consideration here. It wasn't a consideration of lack of remorse. It was consideration of the truthfulness of her trial testimony. And as
if the defendant was less than honest with the pretrial sentence, the person, officer, whoever prepared the report, would that indicate a lack of remorse?
Well, I'm not sure if it would indicate a lack of remorse or not, but I know that it wouldn't affect the consideration of the truthfulness of her testimony. That's because the problem inherent in considering the truthfulness of trial testimony is you put the defendant in a catch-22, whereby they can either testify and then be punished, or they can testify and then be punished for their lack of candor. So it's to avoid that, we consider the consideration of the truthfulness of their testimony an improper sentencing factor. The lack of remorse, I think, is a separate issue, and it's not related to the ground that we raised on appeal.
Counsel, was the trial court required to accept the PSI then?
Oh, no, Your Honor. It's simply a recommendation to the judge. But
I mean, as far as the answers in the PSI, what was the trial court to do? Did the trial court have to accept the appellant's answers in the PSI?
No, no, the court wasn't required to accept anything in the PSI as true. They were required at least to consider what's in the pre-sentence investigation, but no more than that. If it's just a recommendation to the court, the problem is in considering the truthfulness of her trial testimony in determining the appropriate sentence.
What happens if the trial testimony conflicts with your client's representations that appear in the PSI?
The same thing that would happen if her trial testimony conflicted with her sentencing testimony, for example. The appropriate action when a judge or the state attorney believes the defendant has lied under oath is to commence an action for perjury, not to punish them in the instant offense.
There's two different things, right? There's, I don't believe what you're saying at sentencing, right? And then that seems different than I don't believe what you said during the trial. Do you agree, or do you think those are the same things?
Well, it would depend on the context, I believe. So it depends on what specifically you're talking about. And in the context here, she's specifically referencing her trial testimony and saying, I don't believe your trial testimony regarding these pills was true. She says that I find that to 100% lack credibility. And she's specifically referring to trial testimony. So it's not the statement in the PSI that is at issue. It's her trial testimony being considered, and that creates the appearance that it affected the sentence. So if I could turn back to point one, which is I think the bigger issue. There's essentially two sub issues with point one. First, we have the obvious one, which is whether or not the amendment to the stand your ground statute actually applies to this case. The second has to do with remedy, which is more of a factual determination of whether or not there's an alternative ruling in the court's order. So turning to the first sub-issue first, I think there's at least three categories of reasons why it's clear that the amendment to the stand your ground statute applies here. The first is the plain language of the Florida Supreme Court's opinion in Love. Throughout that opinion, they refer to the amendment or to the hearings that this applies to, and they say those immunity hearings taking place on or after, all immunity hearings taking place on or after, all stand your ground immunity hearings conducted after the statute's on or after the statute's effective date. This language of all is, I know this isn't a statutory construction argument, but the language of all is unequivocal here. And obviously it would apply to the second half of this hearing, which is occurring 6 months after the effective date of the amendment, which was Friday, June 9th of 2017. But similarly, there's also no exception to this. It's all hearings, but there's not a way for what the state is attempting to do here, which is to essentially grandfather in a prior version of the statute just because it began before. And I also note that there's nothing in the opinion that says that the beginning of the hearing controls or any reference to the beginning of the hearing at all. And that's probably because it just doesn't matter. This is reinforced by the second category of things, which is the context in which that plain language appears. The reason for the court's decision in Love was based off of the maxim that's in the Supreme Court case of Landgraf, which is that the court is to apply the law as it exists at the time that the case is before it. So when the court is saying all hearings conducted on or after, it's not considering when the hearing began, because the point is, what is the law at the time that the court is rendering its decision? So here we have a hearing that's taking place 6 months after, and importantly, it's also in its beginning phases. The defense is still presenting evidence. The defense, the moving party, the first party to present evidence, is still presenting evidence when this hearing continues on its second day, 6 months after the amendment to the statute in June of the previous year. So, and then continues to present evidence for the remainder of that hearing, which is roughly equal length. We heard from the victim in the first hearing, we heard from Nadine Davis in the second, and then we also heard in the state's case in the second from Detective Slater. So the point of the court's ruling was that the law in effect at the time is what controls. So when we're 6 months later, there's no reason to go back in time and go back to this prior pre-amendment version of the statute. The point is that the law at the time, this procedural change in the law had been in effect for 6 months. So that's what controlled the trial court's decision. The third point is just kind of the catch-all of the absurdities that follow from the alternative interpretation that's advanced by the state. I pointed out this briefly in the briefs, but the problem with the state's interpretation is that it leads to an absurd result. You would end up in a situation.
Let me stop
Yes.
here. Let's assume that the statute should have been applied where the state had the burden. Where do we go from there?
So turning to the issue of remedy, the question is really a factual one of whether or not the trial court's order contains an alternative ruling. The state points out that this isn't as explicit as it was in Meyer, and obviously I agree. The court doesn't outright say the state did not meet the clear and convincing evidence standard, but it's clear from the court's order that that's exactly what it was saying. The language from the court's order is that should an appellate court decide that the state bears the burden in this instance, the outcome would be different. Well, the outcome can only refer to who is winning the hearing. I'm unaware of any other alternative interpretation. The state hasn't provided one, and if they have one, I'd love to hear it today.
Was that consistent with the judge's actions after the trial? Because I believe after the trial, one of our sister courts came down in a way that was favorable to you. And the judge did not say, okay, Miss Davis, you're discharged. Instead, the judge said, okay, we need to have another hearing. Would you agree with that?
Yeah, I agree that that's what happened. I believe you're referring to her vacating her order, denying the motion for immunity, and then after that, vacating the order, denying the motion for immunity. I think the reason that the court did that, and I don't know for certain, but it seems reasonable that the court did that because it wasn't from this court. This court didn't weigh in on the issue until its decision in Fuller, which was some months later.
The trial court would have been bound by that appellate court decision at the time because it's the only one out there, right?
It would have, and I think that was also the reason for the continuance initially. The first continuance, they mentioned this at the start of the second hearing in January, but the reason for the continuance was that there was this decision from an appellate court saying that, oh, well, this is retroactive, and then within a week or two, there was a conflicting decision, which was, I believe, the Martin case that was a certified conflict case.
Well, let me ask you this. I know
yes.
You're asking for discharge, but in a recent opinion of ours, DeRose say, I believe, it's actually a standing ground case involving Judge Lemonitis as well. But there we talked about the fact that if you know you have the burden, and if the burden might be different, you might proceed differently, and the whole hearing might be different as far as the presentation of witnesses, who's called, et cetera. Why should we assume, why should we assume that the state would have put on the same case if they knew that they had the burden, as opposed to if they believed, based on the judge's statements, that the defendant had the burden?
Well, I can't speak for the state. I don't know what case they would put on again, but I do know that they were well aware of the amendment to the statute at the time. And I also know that they were able to present evidence and just didn't, they wanted to go under this other burden, and naturally so. I mean, the burden was more favorable under the pre-amendment version than the post-amendment version. But I don't think the state can get a second bite at the apple here because they just didn't present enough evidence to meet the burden in the first place after convincing the court of the wrong burden. I don't know what the state would have presented, but the difference between this case and Darrosset is that we have and I may be mispronouncing that name, but the difference between this and that case is I do not believe in that case you had a alternative ruling from the court as to who would prevail under the other standard. That's what makes this case more like Myers and less like that. So as in Myers, where you have an alternative ruling under the appropriate standard, then the remedy should be to simply apply the court's ruling under the correct standard, since there's no, which is supported by the fact that there's no lying in wait problem or a surprise problem here. The state was well aware of the change in the law at the first hearing, because at the first hearing, which was just a month or so before, a little over a month before the amendment, that hearing begins with the defense counsel bringing up the fact that this law was about to change. So everyone knew that this law was changing, and after it changed, they immediately moved to continue given the change in the law. And at the start of the second hearing, the defense pointed out that this new law is what applied, and the state fought tooth and nail against it. So I don't think the state should get the benefit of another hearing on this when they failed to meet their burden at the first one.
How does the Dennis case apply here? We did have a jury that found your client guilty beyond a reasonable doubt. Your client presented a self-defense, stand your ground defense at trial, and the jury found your client guilty beyond a reasonable doubt. How do you, and the Supreme Court had a case where the trial judge hadn't even held a stand your ground hearing. They said that was error, but given the jury's verdict, it was harmless error.
I think the difference between this and that case is that we actually do have an immunity hearing. And the difference is it's not merely one of an affirmative defense applying. This is immunity from even being held in custody. So because we have a ruling from the court under both standards, and because we know that my client would have been granted immunity had the court simply applied the proper standard, I don't think we trigger any of the issues that are inherent in Dennis where we didn't have an immunity hearing at all.
Right.
So
with about 5 minutes, do you wish to save the remainder of the time?
I would. Thank you, Your Honor.
May it please the court. My name is Kaylee Tapman on behalf of the state of Florida. I would like to turn to the second issue, the sentencing issue first. And I'd like to say that, we did not forfeit our argument as to that issue. As your honorable judges noted, the trial court was commenting as to her statements in the PSI and not considering an impermissible factor in imposing sentence. If anything, the court was just thinking out loud and commenting on why she didn't want to go with the recommended DOC sentence that defense counsel urged her to impose. This is not a case where the defendant committed perjury and is now being punished for it. This is just a case where the court is considering the trial testimony versus the PSI statement. And further, the trial court did not base the sentence solely on those statements. She found that the sentence was based on all the facts and circumstances of the case before her. Turning to the first.
Counsel, don't you agree though that our precedent makes it pretty difficult for a trial judge to make these types of comments immediately before sentencing and avoid a reversal?
In this court's case in Borado in 2002, the trial court actually called the defendant a liar. But this court ultimately found that it wasn't a factor in sentencing because the trial court statements were in consideration of the defendant's sentencing testimony that he had turned over a new leaf, and that's why he should be given a lesser sentence. And in this case, I think the trial court was just considering the statements made in the PSI, which were made as part of the sentencing, made prior to sentencing, for sentencing, in determining why, to explain why she was not going to grant downward departure and not follow the DOC's recommendation. As to the first issue, the state would submit that the trial court employed the correct standard of proof at the hearing because it ended the hearing with the same standard burden of proof that it began the hearing with. The first half of the hearing was on April 27th. At the conclusion of that hearing, which concluded just because they ran out of time, they set it for May 31st. And then it was continued another 6 times. Had the hearing concluded on April 27th, had the hearing concluded on May 31st, this wouldn't be an issue and we wouldn't be here.
Counsel, how do you address the argument that the court should make its decision in accordance with the law as it exists at the time of the decision?
In Landgraft, where that statement comes from, it's preceded by the words "in many cases" or "in most cases." And in this case, the state would submit that this is not one of those cases. This is a very unique factual situation. I don't think it's going to come up a lot, and I don't think it has come up a lot. I was frankly unable to find any case law talking about a change in the law in the middle of a hearing or the middle of a trial, and whether the new law would apply to the second half than it would in the first half. By the time the second half of the hearing came around, the parties were discussing whether the new standard should apply. And the trial court noted that it would be madness to change the rules in the middle of the game and that it wouldn't make sense. The defendant had already begun bearing the standard of proof it did at the first half of the hearing, which was the law at that time. And it would only be fair to continue to employ the same burden of proof in the second half of the hearing. You know, Love was talking about how it only applied to, the new standard only applied to immunity hearings that take place on or after the effective date. Well, this hearing started prior to the effective date. If the hearing had started, you know, with just 1 to 2 days and it had started on June 9th and the law came into effect the next day, that's a closer, would it affect it in the same way? And further, even if this court were to find that the trial court should have used the amended standard, the state would submit that any error was harmless due to Davis. The defendant was given a fair trial. She was able to advance her theory of self-defense. She testified on her own behalf. The jury was instructed on justifiable use of force, and the jury ultimately rejected her theory and her theory of defense. The state in that context had to bore the burden of proof. It had to prove her guilt beyond a reasonable doubt, which is a much higher standard than clear and convincing evidence, and it was able to do so as found by the jury decision. The appellant has not argued that the pretrial ruling in any way diminished her capacity to advance a theory of self-defense at trial. It didn't affect her preparations, she was able to present the case that she wanted to present at trial, and she received a fair trial. As to the alternative argument, the state would submit that the outcome would be different is ambiguous because of the context of the rest of the order. The trial court it says at one point, even assuming that the defendant's testimony is true, that it was its duty to determine whether she had a reasonable belief that deadly force was necessary, and ultimately concluded that she did not. And then considering the trial court statements at the sentencing hearing, when the defense counsel advanced this argument that, well, if the state didn't meet clear and convincing at the evidentiary hearing, then clearly it didn't meet beyond a reasonable doubt. The trial court found that the evidence wasn't exact. The state brought out more detail. There were better pictures. And so when the state had the opportunity to bear the burden of proof, it did so beyond a reasonable doubt, a higher standard than clear and convincing evidence as demonstrated by the jury verdict. And so in that sense, should this court determine that the trial court employed the wrong standard and that it isn't harmless, the state would submit that it should remand for a new immunity hearing rather than discharge. Are there any questions?
Okay, Mel, thank you.
Thank you. We ask that you affirm.
Mr. Pierce, let me tell you something that concerns me, and I want you to address it. There can be tactical reasons why the state any litigant may hold back evidence. They have a different burden of proof, both as to the burden going forward and the burden of proving the case. Concerns me the idea that when the judge says, okay, here's how we're going to proceed, the burden is on the defendant, and they have to prove it by preponderance of the evidence. Then say, and then at the conclusion of the hearing, the judge rules. But then to come in and say, we should assume, that the evidence would be identical if we had known that the state had the burden of proof and they were going to go first and they had to prove by clear and convincing evidence. It just seems to me that, to change the rules like that and then to assume that the case would have been exactly the same, the evidence presented the same, is somewhat unfair. That's my concern about, one of my concerns about your arguments. Maybe you could address that.
Certainly. Well, I understand the concern, but my response would be that the controlling issue would be, or the controlling decision, I think, would be the district court's opinion in Myers, because the real
that case has not become final for whatever reason. I don't know why.
I don't know why that is either. It's still, I checked this morning and it was still pending. It's been the reply brief's been or it was cited in the reply brief, and that's been filed for some time. So I don't know why that's not final yet. I know this court cited it in an opinion since then, but not for that purpose. In any event, the response to that would be, while I understand the court's concern, the issue is whether or not the issue is what the court's ruling would have been under the appropriate standard. And I don't think there is a lying in wait problem or a bias or prejudice problem, because everyone was aware at the time what the change in the law was. And I don't think the state should be able to get the benefit of a new hearing when they were able to convince the court of the wrong legal conclusion below. I wanted to make one point regarding the context of the order, because the remedy here, I think, turns on that. The state made the point or asserted that the context of the order makes it clear that that it's somehow ambiguous from the order what the court's ruling would be. I think it's exactly the opposite. The court's order, after it says the phrase that we're all examining here, should an appellate court decide that the state bears the burden, in this instance, the outcome would be different. The very next paragraph begins with, in fact, I think it's the next sentence, begins with the court saying that it's now in the unenviable position of trying to figure out what happened. And then it concludes that short 3-sentence paragraph by saying it doesn't find either witness to be particularly credible. This is why we know that the burden of proof is what determines the issue. It's dispositive for the purposes of this point. The court has before it 2 witnesses. It doesn't believe that either of those witnesses are credible. The defendant bears the burden, therefore the defendant loses.
Was there a third witness?
There were 3, but it was in its order. It was just going back and forth between.
Did the police officer testifying about the inconsistent statement given by your client after?
That's how it was introduced. Yeah, the court's order begins by comparing the 2 statements: the post Miranda statement and then her testimony at trial. And the post Miranda statement came in through.
At the stand your ground here? About the
I
nature
can't.
of the wounds and the angles, etc.
I don't recall. I frankly don't recall if there was medical testimony at that hearing.
Trial?
Yes, and that was one of the other points I wanted to make, was that the state has hung their hat on the fact that they proved their case at trial, but they did so by their own admission with more evidence. So I don't think the fact that they met the burden at trial it matters at all for the purposes of immunity. And to that end, they also pointed out or asserted, well, there's no issue here because the defendant didn't make any claim of procedural prejudice in their preparations for trial. But procedural prejudice isn't the point. We have per se prejudice here. This is an immunity hearing. So she wasn't even allowed to be held in custody, let alone proceed to trial. The fact that she was. The
possibility that upon the completion of your case, the state felt your client, and that the judge wouldn't find your client had met the burden, but if they had the burden of clear and convincing, they would have brought the additional evidence they brought at trial. Can we eliminate that possibility?
I'm sorry, could you repeat that one more time?
Can we eliminate the possibility that if the state had known that they had the burden of proof and that burden of proof was clear and convincing evidence, that they would have put on that additional testimony at the stand your ground hearing, as opposed to believing that your client hadn't met the burden in the first place?
Well, I don't think that testimony would have affected the credibility determination that was eventually dispositive of the court's decision. So yes, in a way, we know that it doesn't matter because we know that the court's real decision was over who was more credible. They didn't find either credible, and because of the burden at the time, the court erroneously believed it applied to the defense. The court held that the defendant lost. However, if the burden applied to the state, should an appellate court decide that the state bears the burden in this instance, it would have applied to the state would have lost, my client would have been granted immunity. And anything after that point, the prejudice is per se. The prejudice is inherent in being charged, going to trial at all, because this is an immunity hearing, not simply a claim of affirmative defense prior to trial. I see that I've run out of my time, and I would request this court reverse.
All right, thank you both.
Thank you very much.
Thank you.
Nice job, both sides.